All right, we're going to go live here. This is our court case from yesterday. It's only in audio form. And I want all the naysayers to listen. Listen closely to what the judge says and what he has written into the journal about my future lawsuits against members of the Lorain City government. Okay? Let's listen to Judge Kimbler, myself, Robert Gargis, and Patrick Ward, and whoever the bailiffs are. This is audio only. There's no visual. I will probably have this transcribed for future lawsuits and future court cases.
All rise for visiting Judge James Kimbler.
We have to, we'd like to see you. Thank you very much.
The court is on.
Yeah.
I'll grab it. Again, please turn off and silence all cell phones, no phones in court, please. Thank you. Right there, Judge.
I want you to spend, after you do the change of plea, I want you to spend some time draft the journal entry right here, because you got language you guys want into it, and then I can sign it before I go. So that's the plan. The plan is to have you do my work, because it says me draft the entry, you draft the entry, and I read it over. And that way we're all happy. Yes, I'm happy. I don't you guys happy. So what plea is the entry?
No contest, Your Honor, to the charge of disorderly conduct, a minor misdemeanor.
With waiver of taking the facts?
Yes, Your Honor.
Okay.
And the waiver, we also have the language that we referred to earlier, the handwritten document.
Just for the record, Your Honor, the charge that Attorney Gargis is referencing is disorderly conduct under Revised Code 2917.11A2.
Okay, is that in the charge or is that in the amendment?
That is in the
Complaint?
that is in the bill of particulars.
I got it.
And in the complaint as well.
I got it. Do you know where it would be inside this? Hold on a second.
It appears the summons was originally issued
Language in the summons.
on August 8th of last year, Judge.
Well, right now it's September 24th. Appearance to the city of. Do you have the language there? Do you have the copy of the complaint?
I do, and I also have the bill of particulars if you
Yeah,
like.
I need when you got your copy of the complaint. I just need to charge in the commissioner.
It's just the first page, the first and second page, actually, of this packet.
Oh, we have a record.
We are your own.
We're calling case number 2024 CRB 02378, State of Ohio, as the plaintiff versus Aaron. Is it your first name? Yes, sir. Yes. Aaron Franklin Petty as the defendant. We're here today. We were set for a jury trial would have commenced on Monday, October 8th.
6th.
October 6th. However, the court was informed there was a pre-trial, I believe, on Monday or Tuesday. It was after that pre-trial, there was communication to the court. It's communication to the court that the parties had reached a plea. The terms of the plea bargaining agreement were that Mr. Petty, the state of Ohio, dismissed the charge of criminal trespass. Mr. Petty entered a no-contest plea of waiving the taking of evidence or facts in disorderly conduct. The court would make a finding guilty on that and impose a $100 fine and waive the court costs. And the reason why the court's waiving the court costs is these court costs, there's two charges here. I don't know how the clerk would go through this and try to figure out what court cost goes with what charge, so I'm just going to, we're going to do a waiver and that'll be easier for everybody. I usually, again, Mr. Petty, you're going to be in a position to plead pay the fine today?
Yes.
Okay.
Your Honor, if I could, I just wanted to make sure the record reflects that he's entering a plea of no contest.
Right.
And that you're finding him guilty. He's not entering a plea of guilty.
No, I'm going to get to that. He and I are about to do we're about to have a conversation. So what happens at the end of this conversation, it'll be pretty clear what we're doing. Mr. Petty, I know that your attorney spent a lot of time doing this case. I know that I'm pretty aware you're pretty understanding what's going on. But I do have to ask you a series of questions in order to comply with decisions of the United States and the House Supreme Court, so please bear with me. Please state your full name, sir.
Gary Franklin Petty?
Are you an American citizen?
Yes, sir.
Do you read, write, and speak the English language?
Yes, sir.
Are you now today under the influence of alcohol or drugs of abuse?
No, sir.
Are you 18 years of age or older?
Yes, sir.
You're here today out the record. The reason why I say that is I was once taking a change of plea, doing a rating on a person who sought kind of come to his court, and I realized he was 17 when he committed the offense allegedly. And so I said, we have jurisdiction over this judge. They had to dismiss the case, so that's why I always ask that sort of thing. So you're here to get a criminal case. The criminal case, there are 4 pleas that you may enter. They are a plea of not guilty that denies each and every element of the offense, a plea of not guilty by reason of insanity, since you did the offense but you were legally insane, therefore not culpable, a plea of guilty, which is a total admission of your guilt, and a permission of the court, a plea of no contest. A plea of no contest is not an admission of your guilt, but it is an admission of the truth of the facts set forth in the charging document. If the facts set forth in the charging document constitute a criminal offense, you can and will be found guilty on a plea of no contest and treated as if you pled guilty. But the fact you entered that plea cannot be used against you in a subsequent similar criminal lawsuit. So if someone sued you civilly and tried to use a plea of no contest against you, they cannot do that. Okay. But in terms of my ability to find you after you enter the plea of no contest, and after I make the finding guilty, I can't do that. You understand this so far?
Yes, sir.
Okay. When you enter a plea of guilty or a plea of no contest, you're actually waiving the same constitutional rights. In this case, you're waiving the following rights: the right to a trial, the right to have your guilt proven by proof beyond a reasonable doubt, the right to subpoena witnesses on your own behalf, the right to cross-examine witnesses called to state against you, the right to have the services of your attorney at trial. You give up your right not to incriminate yourself, and you give up your right to a speedy trial. You understand you're giving up those rights?
Yes, sir.
You understand you went to trial, you would not have had to testify, and the fact you did not testify cannot be used against you. You understand that?
Yes, sir.
Am I missing the charge here? Where did you skip to?
I did, Your Honor. It's identified on the first 2 pages of the set of documents that I provided.
Oh, okay, I got it, yeah. Okay. The charge against you is, on this case, the violation of 2917.11A2. The charge is on or about July 1st, 2024, in the city of Lorraine, county of Lorraine, state of Ohio. You did recklessly cause inconvenience, annoyance, or alarm to another by making an unreasonable noise or an offensive force, utterance, gesture, display, or communicating unwarranted and grossly abusive language to any person, and this is in violation of Revised Code Section 2917.11A2, disorderly conduct. Minor misdemeanor carries a fine either up to 100 or up to 150, but carries no jail sentence. In this case, the court plans to impose a $100 fine and waive court cuts. First of all, do you understand the nature of the charge?
Yes, sir.
Do you understand the nature of both the possible penalty and the penalty I plan to impose?
Yes, sir.
How do you plead?
No contest.
And do you now waive, Attorney Gargis, do you now waive presentation of facts?
Yes, Your Honor.
Anything further on the change of plea from the state of Ohio, just on the change of plea?
No, Your Honor.
Anything further on the change of plea from the defense counsel?
Your Honor, I just want to read for the record that
Okay.
if it's possible that the plea and entry does not affect any pending or future civil claims brought by defendant relating to the events of July 1st, 2024, or any allegations arising therefrom.
Yeah, and I think also, we want to get, I think you indicated Attorney Ward indicated by emailing me a copy to you that you plan to have, you want that language in the journal entry.
Correct, Your Honor.
Judgment entry, I should say. All right.
Your Honor, the only other thing I would ask is that we have a record preserved of this hearing, and so that it can be printed up for public record if needed in the future.
Yeah, I didn't do that.
Your Honor, the audio record is there.
Okay.
Attorney Dargis could have a flash drive or email.
That would work, a flash drive or email.
Okay. The clerk of court, you just request that at the clerk of courts.
Okay.
Thank you.
Sure. Mr. Petty, is there anything, I think you know what I'm going to do, but is there anything you want to tell me before I do it?
Thank you for being an honorable judge. Thank the prosecutor, thank my attorney that we've worked this out, and hopefully that in the future none of this ever happens again to American citizens.
All right. I like that. $100 fine, court costs are waived, and case is concluded. Mr. Petty, for the record, he has 7 days to pay, but if he pays a day, that would be even better. Okay?
Thank you.
Yeah, okay, you guys should work on
Your Honor.
So where do you want them to work on the entry? How do you want to do that? You have a form entry you want them to look at, they can add to it, how do you want to do that?
Do you have a draft yourself, Attorney Dargis, or?
We have kind of a written draft that needs to be typed up.
I don't know if we have a computer available on the premises for them to use, Your Honor.
You're going away, right? You're leaving?
I am leaving this afternoon.
Is that,
Okay.
is that something that could be submitted to the court?
Well, the only problem, not the problem, it can be submitted to the court later on, that's for sure. The only problem that we could run into is I don't think your clerk can collect the $100 until we have the entry file, because there's no record that says he owes $100 until we have the entry file.
Do we have a short card that we could write on?
We can do that.
Give me something to write on. Well, you know what? My writing is horrible. If you guys the best writing out there, you guys should write it, because my writing is horrible.
Your Honor,
If I don't know this, you couldn't read it.
And these are just plain blank papers?
and then we'll transfer that onto a short card, actual journal entry typed in.
Oh, okay.
If that is okay with the board.
Yeah, that's fine.
And both parties can review it before it gets typed, before and after signatures.
I got nothing going on until like 12 o'clock, so I can hang out.
May I ask, what is customary in this court when there's a plea? Is there a form that's
We have
generated?
We have a standard journal entry, but in this case, there's special verbiage that wouldn't normally fit on a standard journal entry.
Yeah.
Well, it might be easier to, could you give us the standard journal entry and then we can just add to it? And then they can type it up? Because otherwise, I think that might be faster than typing out all the standard language. Do you know what I mean? That's in every...
However you'd like it, we could make it work.
I was gonna, however you want to do it, I was just gonna try to put something together that they could type in. And we can incorporate by reference, the handwritten one too, that way there's no...
I want the attorneys to be happy with what's happening before I leave. I want the attorneys to know what we're doing, and I want to know what we're doing, and I want the attorneys to be signing off on it before I leave the courthouse. That's all I'm saying. So however you get there, I could care.
Could we see the standard plea and sentencing entry?
Sure. Yeah, you check one out for me. Or you check one out for every year.
Plea and sentencing.
Yes. And then we'll have to add, because our standard sentencing entry if there's, say more than a sentence or two, will not be able to fit that much verbiage on it. They may have to do an additional page to that.
That's fine.
Sentencing. So we could
That's fine.
that way, or we could do a.
I know that every court has certain language that they put in plea and sentencing entries, so I thought we could just copy what's customarily used here and then supplement it with the language that's specific to this case.
The judge is okay with that?
Yeah,
Both parties agree.
Whatever you guys work out an agreement, I'm fine.
Okay, let's do that.
Whatever you want to do.
I want to get this over with so I can pay today.
Yeah.
We should be able to do it.
And that's it for that. Garen Petty, October 2nd, 6:34. I'm out.